Ready? Come on. No, man, we should just be able to sit down and then y'all get started talking to them. If they cannot hear you, or you cannot hear them, let me and Ms. Clarkson.
Mrs. Adelson, can you hear me?
Yes, I can.
All right. Let's do a mic check so you can hear everything happening in the room. Mr. Zellman?
Joshua Zellman on behalf of Mrs. Adelson.
Jackie Fulford on behalf of Mrs. Adelson.
Sir Catherine Dugan on behalf of the state.
All right, for everyone who has joined the Zoom this afternoon, there is not to be any recording of the Zoom. The pool camera is the only designated camera that is going to be recording the proceedings today. We're here this afternoon on the defendant's expedited motion to continue the trial. The state has filed a response to this as well, and the defendant has filed a reply. In addition, the defendant has also filed a motion to compel. Mr. Zellman, you may argue your motion.
Your Honor, before we do that, I believe that the email from your office also indicated that you wanted to address the scope of the sealing. That
We'll get to that at the end, but unless you believe we need to do it right now.
Given the nature of the materials and the basis for the, in part, the basis for the continuance as well as the motion to compel, we would request that it be addressed at the beginning of the hearing.
Very well. Concerning the scope of the sealing, when this matter was first presented to me, when we had the phone conference on April 8th, as it related to matters pertaining to the warrants and any affidavits and any support for those as to the investigation that recently concluded, I am in agreement with you, those matters would be confidential. However, every filing that may even reference those materials, sealing those filings starts to become a question of whether things are exceeding the scope of confidentiality that's allowed by the rule of general administration. Mr. Zellman, why should all of these matters remain sealed without redaction or other means that could be made to otherwise deal with the portions that are confidential?
Well, Judge, Jackie Fulford on behalf of Mrs. Adelson, our position is that the information that's contained in the items that Your Honor is referring to would need to be referred to also in the arguing of these motions, and we're here in open court, and I'm not sure how we protect the sealing of those documents when we're going to have to argue the very materials that serve the basis of why we're here asking for a continuance and a motion to compel.
Is anyone actually getting into the warrants or the affidavits themselves with what you plan to argue?
Yes, Judge, and the materials from the investigation.
You have those to actually bring up as a part of your argument today?
Yes, Judge.
Not generally, not just referencing them, but the actual materials from the warrants and the affidavits.
Well, there need to be statements put on the record on behalf of Mrs. Adelson regarding what was claimed to have happened in the investigation that has since proven to be false, that has not been retracted by the state. And in making those arguments is part of the basis for why we need a continuance and why we're asking for the relief in the motion to compel, as well as additional depositions. And
to that end, Ms. Dugan, is the state planning to file any superseding indictment or any additional charges based on the investigation that has now concluded, or at least is alleged to have concluded?
No, sir, not to my knowledge.
With that being said, if the defense is seeking to file any motions related to these matters, they are not related to pending counts. However, you can pursue them as you believe them to be appropriate. As to the warrants and the applications, does the state have a position as to whether they should remain sealed or any documents referencing them should remain sealed without redaction?
No, sir. We would defer to the court. And some of the discovery the defense has moved to compel is sealed, or a lot of it is, and I actually brought a motion to unseal the documents and recordings related to that today so that those can be provided to the defense, but maybe for the limited purpose of discovery, but whatever the court prefers, we don't have a position.
Mr. Zellman was full for any additional argument.
No, Your Honor.
With there not being additional charges to be filed by the state concerning these matters, the court is going to unseal at this point the filings that have been previously filed under seal as it relates to the motion for continuance, the state's response, and also the reply as well. Any other matters that need to be reviewed by the court or to be unsealed from here, the parties need to appropriately raise.
May we have just a moment, please?
Go ahead.
Your Honor, if I could just ask for clarification, are you indicating that you're unsealing the pleadings but not the actual underlying applications, affidavits, and warrants, or you're unsealing
Not the
everything?
warrants, not the affidavits, not the applications, but the pleadings that reference those matters, yes.
Just one moment, please.
Your Honor, would you give the defense an opportunity to propose redactions to the pleadings, given that they relate directly to those underlying materials, and in fact, in some points, quote them?
Absolutely.
Thank you.
Again, as to redacting those matters, that would remain sealed. That is certainly appropriate under the rule of general administration. As to each doc or each docket entry or each document itself remaining sealed, just by incorporating by reference those matters, I believe that's getting a little bit further than what the rule requires.
Yes, sir.
Mr. Zeldin, you may make your argument at this point.
Your Honor, the expedited motion to continue that was filed on April 21st, I try to make my arguments as clear as possible in the written pleadings. What has come out about 3 weeks ago is the state conducted this additional investigation into allegations. As part of that, they obtained additional records. We also learned approximately 2 weeks ago during Investigator Newland's deposition that the state had not given us materials that had been given to prior counsel. So we've been asked to trust without the ability to verify. And in fact, months ago, I asked the state for a list of the materials, everything that they had, everything that Corbett had, so that we knew if we had received everything. And they did not provide that to us. So now we have received, from the materials we received over the last few weeks, it appears to be over 100,000 emails. We have purchased 3 pieces of software in addition to the software that we used previously, trying to...
Is this to sort through or sift the emails?
Some of it's to open it, some of it's to sort through. Yes, Your Honor.
Go ahead.
None of them are very effective at doing that. So we've actually engaged a e-discovery platform to assist us, but that hasn't even been set up yet. That was a decision that we made last night after trying that additional piece of software yesterday. In addition to that, we have new Cellbrite extractions from Mrs. Adelson's phone. I understand in the state's response to the motion to continue that they don't intend to use any of that, but that doesn't mean that there's not something in there that we want to use.
And I did want clarification on that point. As to the discovery provided to prior counsel, Ms. Dugan, the response of the state is that on October 31st and November 8th, the raw data from the defendant's phone and email accounts were provided. Is that correct? Is that what your response is getting to?
Is this concerning, can you tell me what...
Just the raw data from the defendant's phone and email accounts?
Yes, sir. Those have all been previously provided. I thought he was talking about the
We're going to get to the filter team documents. The best way to do this is to take it into bite-sized pieces so it's clear what is being argued, what is not.
Yes, sir. So it's my understanding that all of Mrs. Adelson's phone records were previously provided in November 2024. There were certain phone records, I believe it was 7 pages of phone records that were actually, this is going to be paragraph 7 of the defense's reply to the response. These are phone records that Donna Adelson's prior defense counsel had an issue with us not having. So these were subpoenaed. TPD received them in October of 2024. The state attorney's office didn't know TPD had received them. TPD didn't know that we didn't have them, and so that's why they weren't disclosed. But ultimately, they have now been sent to the defense.
Another term you start to hear sort of thrown around a little bit more by
Ultimately, though.
Go ahead.
Yes, sir. I'm told it's 7 pages of records. So those were the 7 pages that they did not have, that weren't disclosed to them last fall. That's my understanding. And we would object to a continuance based on those pages.
All right, as to any additional raw data from either your client's phone or email accounts, are these not in your possession at this point?
We have them, but that's the materials that we've been struggling to try to get through.
And again, this was disclosed back in October and November, or when did you receive it?
We did not receive those materials, Your Honor, until it was after, if Your Honor recalls, during the expedited hearing that we had a couple of weeks ago by telephone with the state and defense on the phone. Those were the records that we were addressing then, and I believe that we got those April 10th, 2025. And that's, the state actually acknowledges that in their response.
All right, Mr. Zellman, you're not going to make your argument for you, but ultimately you believe you need to review these to be prepared for trial itself.
Yes, and those aren't the only issues that have arisen over the last few weeks. The motion details the additional issues, but needless to say, we have spent the last 3 weeks trying to collect this material, some of which we still don't have.
You're referring to the recent investigation?
Yes.
Go ahead.
And even if the state isn't going to use the information, we still need to know the extent to which they violated, they intercepted and monitored attorney-client communications and communications that are protected by the fiduciary client privilege. We don't have all of that information yet, and they have not responded, as indicated in my reply yesterday. The state hasn't responded to those emails requesting that information.
Ms. Dugan,
Yes, sir.
concerning the aspect of the recent investigation, which materials are yet to be provided and why?
Yes, sir. May I also address the 100,000 emails?
Go ahead.
Okay. So those 100,000 emails are redacted privileged communications that the defense recently received that occurred between the Adelsons and prior counsel. This communication was redacted by a taint team. It's never been seen by the prosecution.
The filter team document you're
Yes, sir,
referring
thank you,
to.
filter team. It's never been seen by the prosecution. It's obviously privileged. We obviously do not intend to use it in our case, having never seen it. And I also can't imagine a scenario where the defense would be using it in their case. I would feel like all of that information would be hearsay and self-serving hearsay. So the state is objecting to a continuance based on their needing to review all of the privileged communications with prior counsel.
When were the filter team documents provided?
They were provided on April 10th during, one second, I want to double check. During Jason Newland's deposition by this defense team, somehow some question was asked where he referred to the filter team that the court referenced, and this defense team was not aware that the filter team had gone through all of those emails and kept all of the privileged emails from the prosecution team and provided them to former defense counsel. So those were then provided to this defense team.
Very well.
And Your Honor, I could address that very briefly. Judge, advice of counsel is something that would be relevant. It goes to Mrs. Adelson's state of mind. And if there are any emails in the records that we received 2 weeks ago that would rise to that level, then it would absolutely be relevant and admissible if it goes to her state of mind concerning, for example, her leaving the country.
Well, I was going to say, particularly as to that issue, what advice she received and what she relied upon in making that decision, that would be up to the finder of fact to determine, was she relying on the advice of counsel or was she in fact trying to flee? The emails, though, and your client does not have to testify, but ultimately this would go to how would the emails themselves be admitted versus her giving her recollection or recitation of those.
That still doesn't mean that the emails themselves would not be admissible, Your Honor.
Let's put a pin in that. That
Yes,
would be
sir.
subject to any argument in the future
Yes,
as
sir.
to how the emails themselves could be admissible. But if your client chooses to take the stand during the trial and waives any prior privilege with Mr. Rashbaum or anyone else concerning advice that she received on leaving the country, that is certainly up to her.
Yes, sir.
Back to the recent investigation discovery, Ms. Dugan, the items that have not been provided, I believe some of these pertain to the parameters in the Title III that were supposed to operate as safeguards. Is there a reason this has not been provided to the defense?
So, looking at the reply and the motion to compel, all of the things that they are requesting here as far as the minimization instructions, all the logs, all of those things, I feel, once the order to unseal has been signed, those can't all be disclosed. The only thing that I saw that would be additional that they are asking for is surveillance video, which is surveillance video from the jail, which I've been told has already been disclosed to the defense. They also asked for the financial records that are mentioned in the application. I was told that we subpoenaed Harvey Adelson's Zelle account. I found that those Zelle records and had it sent to the defense this afternoon. So once those items are unsealed and they can be disclosed to the defense, that should be all of the discovery that pertains to the wire.
Please provide the order. Has the defense been able to take a look at it?
No, sir. Let me show them what I have, and if I need to change anything, I'll be happy to. May I approach?
You may.
Your Honor, there was one issue that Ms. Dugan and I addressed concerning the motion and order, and it has to do with the discrepancy with Investigator Newland's memorandum, the 17-page memorandum. The memorandum that he authored indicated that the wire went down February 24th. Ms. Dugan is telling me that the wire actually went down on February 21st. So if we can just make sure that that's accurate.
Yes, this is one of the paragraphs in the defense's reply. That was just a mistake on a memo. The wire came down on the 21st. I believe the significance of the 24th was that was when the order was signed, and I think Mr. Newland's memo said the 24th, but it is the 21st, which is reflected in the order the court's looking at now.
All right. Court will sign the order at this time. I believe that deals with your motion to compel, Mr. Zellman.
May I address one more thing about the issue we were just talking about? There is obviously this new discovery from this lead that the state was alerted to last fall. We conducted this investigation and followed that investigation to its conclusion. That obviously has resulted in some new discovery in these wire calls, but I did want to let the court know, though there are a large number of calls that the defense, of course, wants to review, there are only, I was told, about 30-something calls deemed pertinent by law enforcement, and the state likely plans to only use maybe 1 or 2 at trial, and believes that the 2 months the defense had from the time it was discovered to the time of trial in June should be sufficient to prepare for that portion of the trial.
Do any of the calls that you intend to use from this recent investigation go to privileged matters or encapsulate calls with counsel?
Thank you. I wanted to address that. There are no calls that were recorded between the defendant, Donna Adelson, and attorneys in this case. I specifically asked the investigator about that before the hearing.
Mr. Zellman, you may continue with your argument.
Yes, Your Honor. The state has also not responded to our request to let us know if they've also been monitoring our attorney-client conferences at the Leon County Detention Center.
That's a no.
And although the state believes that we're going to have enough time, I calculated this. There are over 32 hours of calls that were captured on that wire. And given the amount of materials that we have just been handed, we have not had an opportunity to review even 2 hours of those calls up to this point. Your Honor, just because the state believes that there's going to be enough time for us to prepare, and it's not 2 months, it's more like 6 weeks. There's not enough time for us to analyze this new information, synthesize it, prepare appropriate motions. We've spent the last 3 weeks dealing with this as opposed to finalizing the motions in limine.
That is an important point you bring up. Essentially, between what has been recently investigated and what the charges have been of murder, solicitation, and conspiracy from the time your client is charged, there are essentially 2 different pots, if you will. For the motions that the deadline was today as to the murder, solicitation, and also the last count as well, are those motions completed?
No, Your Honor, we've only had an opportunity to finish 2 additional motions that have not yet been filed, and I have not had an opportunity, because we had to adjourn Investigator Newland's deposition, to finish the Frank's motion.
Right? So you are in fact asking for an extension on the deadline to file your motions.
We're going to need one in addition to the continuance, yes, Your Honor.
Ms. Dugan?
If the court wants to give an extended motion deadline, we don't have any objection to that. We do object to a continuance of the trial and remain ready for trial.
What is the defense, well, before I come back to you, Mr. Zellman, what is the prejudice that the state would suffer if the trial is continued, Ms. Dugan?
We would not
Beyond just a mere objection?
We would not suffer prejudice, Judge. We're just ready for trial if it goes as continued.
Mr. Zellman, what would you be proposing as a date? And you also have to keep in mind, there's only so many points in the year a trial that could take either 3 weeks or more can be scheduled. And I assume you've discussed with your client if your relief is granted.
We have.
What that means.
We have, Your Honor, and frankly, without getting through all of this new material, it's hard for us to pinpoint exactly when. I mean, we're not going to sit around on our hands and do nothing. We have been diligently preparing. We're going to continue to diligently prepare. Likely 2 to 3 months would be, I think, realistic. But again, until we get through all these new materials, it's going to be hard for me to say.
Right. Concerning the motion deadline, which was supposed to be today, we'll set a new deadline, particularly as to the counts that have already been a part of the indictment and have been charged all along. The murder, the conspiracy, the solicitation, the deadline for filing any motions relating to the existing charges will be May 16th. The motion hearing that was scheduled to take place on that day, we will reschedule at a later point. Court is going to reserve ruling as to whether the motion for continuance will be granted. The parties are to confer about any redactions that you believe would be appropriate to the filings for the expedited motion for continuance, the state's response, and also the defendant's reply, and the motion to compel discovery. Any other matters that we need to address before we finish up for today?
Your Honor, with respect to the motion to compel, the state has also not provided the disclosures that's required by Rule 3.2201BM concerning the jailhouse informants. We've also moved to compel that material as well.
Give me a moment, I'm just going to bring up the rule. So this is 1M, which subsection?
1BM.
1BM. Dugan, response?
I'm sorry, Judge, I'm having trouble getting on the Wi-Fi. Is there,
This is in the discovery rule under the prosecutor's discovery obligation. And I will quote from it.
thank you.
Whether the state has any material or information that has been provided by an informant witness, including the substance of any statement allegedly made by the defendant about which the informant witness may testify, a summary of the criminal history record of the informant witness, the time and place under which the defendant's alleged statement was made, whether the informant witness has received or expects to receive anything in exchange for his or her testimony, the informant witness's prior history of cooperation in return for any benefit is known to the prosecutor.
Yes, sir. Thank you for that. I'm familiar with that rule, but just didn't know all of the different things I needed to show there. Some of that has already been provided through the recordings. However, as far as her history, any benefit, all of those things, we'll disclose that to the defense as soon as possible.
Please disclose it by Friday of this week by 5 p.m.
Yes, sir. And may I also ask about, today is the discovery deadline, which the state is prepared to obviously comply with. As far as though, now the order on the continuance maybe being later in the week, would it be okay if we had a discovery deadline of 24 hours from the order, or would you rather keep it for today?
Concerning, again, the charges that have always been in place, the murder, the solicitation, and the conspiracy, is either party seeking more discovery on those charges that has not already been addressed up to this point?
Judge, the issue with complying with today's deadline is we have spent the last 3 weeks dealing with these other issues. We have not.
Not the motions. I'm saying, are
I'm
you
not-
seeking additional discovery on the indictment charges?
We are not going to be able to meet the deadline to provide the state with our discovery because we have been focused for the last 3 weeks on other issues.
Ms. Dugan?
The state can comply with the discovery today. I just didn't know if given the possibility of the case being continued later this week, if it were possible to have 24 more hours after that order came out. But if it needs to be today, the state can comply with that. And the state would hope that the defense can comply to or get discovery as quickly as possible to us.
Once a ruling has been made on the continuance of the trial, the court will also address any deadline for discovery as well. For now, please operate as if the deadline remains in place. Wait for the order.
And Judge, I just want to make it very clear, there's no way we're going to be able to get it done, even if we were to work straight through till midnight.
Again, Mr. Zellman, as to that, what can be filed, please do.
Yes, sir.
I will let you know once we have a motion, or excuse me, once the order is on the motion to continue, whether the deadline for everything else related to today's deadline applies as well.
Yes, sir.
We are in recess. For everyone on the Zoom, that is the end of the hearing today. Take it.